Good morning and welcome to another edition of Legal Access. This time we're going to be talking about real estate law. So if you have any questions about real estate law, make sure you give us a call here today. Our phone lines are always open, 843-848-8080, and we'll be talking about real estate law and taking your questions. On our panel here today to answer all those questions, to my left, first of all, welcome back to Ken Corbett.
Thank you. Glad to be here.
And also to your left, Trenton Redmond.
Good morning.
Trenton Redmond. I want to make sure you get that out correctly. And Kimberly Thompson on the far end of the table for no particular reason. Now, go ahead and explain to everybody who's watching, in addition to real estate law, do you work with anything else at your practice?
Mostly real estate law, commercial and residential, but many times in real estate you're dealing with some probate matters, so
Right.
we also do some wills in estates, no
Right.
trust, but wills in estates.
Right. And Trenton, same question, your firm and what else do you work with besides real estate?
These days I mostly do real estate, but our firm, which is Newby, Sartip, and Mason in Myrtle Beach, we handle all manner of things. So civil litigation, collections work, estate planning,
Right.
wills and trusts, personal injury. So the whole.
And Kim, your firm and what do you do besides real estate law?
So in addition to real estate law, I also do wills and estates, no trusts either
Right.
yet, but maybe one day. And then I also help with some LLC formation, and on the other side of the building we do civil litigation, personal injury, workers' comp, some criminal defense, so a little bit of everything on the litigation side of the building.
Again, our phone lines are open. We're well equipped to answer any of your questions about real estate law here today, or as you heard, basically about estate, wills and not trust, but wills and estates. So first question I have actually was called in after last week's show for this week's show, and it has to do more with estates than real estate, but we'll go ahead and ask it since you guys also work in that venue. The main question was, how do you avoid probate? Is there any way to avoid probate as far as after that? I guess, what are the best ways? Or if there's a way?
The best way, especially when you're doing a real estate closing, if it works for you, is to put your husband and wife or whatever what's called rights of survivorship, which means when one of you die, the house automatically goes to
Right.
the survivor. And with that, you can also set up your bank accounts and your portfolio and all of that with rights of survivorship.
Right.
And normally, that tends to cover everything that says when I die, it all goes to
Right.
John or Mary or Tom without going through probate. But you know, sometimes you have to go through probate. And when your husband and wife,
Right.
especially because that's what makes up most of our audience these days, husband and wives, if the husband dies, it all goes to the wife, then she needs to certainly see
Right.
a lawyer to make sure that when she dies, there are ways to avoid probate, but they're a little more complicated than getting into it over the, over
Right.
this.
Yeah, basically setting up a trust is a good way to do it, but that is complicated at estate planning.
Is it as simple as for things like your property to put the word and rather than or, and the same thing with maybe accounts and stuff like that? Because if one of you passes away, then your name is still on the account?
So and or doesn't have a legal significance on a deed. You'll see and.
Right.
What you need is that survivorship language. So you need,
Okay.
as joint tenants with rights of survivorship or for and during their joint lives, you need that language
Right.
because South Carolina doesn't have tenants by the entirety. With vehicle titles, it's significant, the
Right.
and or the or. Bank accounts, whenever multiple people own a bank account, when one person passes away, the other person becomes the owner of the
Right.
bank account. But you can set up transfer on death provisions to give that bank account to certain people. But the and or the or doesn't control as
Okay.
much as how you're setting it up.
Were you going to say something, Trent?
Well, I was just going to say that I've noticed with some of my clients a common misconception that a simple will help you to avoid probate.
Right.
But a will just directs where your assets go through the probate process. So you do need to take one of those other avenues that we've talked about or form a
Right.
trust.
What's really important, we see a lot of people that are moving from other states, they sometimes forget that the laws here are a little bit different than they are, say, even in North Carolina. Because husband and wife, they don't have to have the magic language on their deed. If the husband dies, the wife gets it automatically. And many times when people pass away, they just assume the Myrtle Beach property or the Horry County property went the same way, and 3 years later, after everyone's already died and probate's closed in New York or North Carolina, they have to reopen an estate here to be able to handle that. So if you have property in more than one state, you certainly are probably a good candidate for a trust lawyer. And there are ways that, like you say, we can help avoid probate or minimize it at in a way. And the other thing about it, probate in South Carolina is not as expensive as it is in New York, New Jersey, Massachusetts. People always assume that's a real expensive process, but it's fairly reasonable, and a lot of it is so self-explanatory that I actually tell clients, you're smart enough to do this on your own.
Real estate law is our topic here today. Give us a call. The phone number's on your screen if you have any real estate law questions. Let's go to Conway right now. John is on the line with us. Hi, John. Thanks for calling in. What's your question today?
Yes, my father passed away, and he had a handwritten will that was notarized, but they were saying in South Carolina it's no good because there wasn't 2 witnesses.
And that makes sense. For a will to be submitted to probate in South Carolina and validly executed, it does need to be notarized in the presence of 2 witnesses that aren't beneficiaries to the estate. So I would assume that the probate court would consider him to have died essentially without a will. Do you have anything you want to add to that?
Well, I'm trying to recall from my law school days.
What exceptions you might
There
need.
are,
Yeah.
if I recall, there is an exception, but I believe it's only in cases where it's a will made in an emergency type situation. But you know, it's something where you can make an appointment with the probate court and meet with them and go through it, and they would be able to tell you definitively whether or not that will can be admitted to probate. So that's what I would recommend doing.
And also, it's my understanding that if it's properly executed and notarized in the state where it was originally done, then it complies.
Correct.
It doesn't have to, a foreign will can be probated in South Carolina as long as it was properly executed in the state where it was originally done. So hopefully for that case, it was in a state done by handwriting in a notary where it was compliant with the state, with that state's law. So you need to maybe check with a lawyer and dig into that.
All right, John, thanks for your call. Hopefully that helps you out, and hopefully that everything works out as far as your situation is concerned. Got a few more questions along the same lines, but tell you what, we're going to head to run to a break right now. When we get back, we'd love to talk to you about real estate law. That's our topic here today on Legal Access, brought to you by the McGuire Law Firm. Welcome back to Legal Access, brought to you by the McGuire Law Firm. Our topic today is real estate law. On our panel to answer those questions for you, we have Ken Corbett, also Trenton Redmond, and Kimberly Thompson. So we're well equipped to answer all your questions about real estate law. A lot of the questions we had in the first segment here had to do with more estates than real estate, but they are, as you've said, intertwined. So I've got one more intertwined question there. Now, as far as a lot of people, we talked about avoiding probate at the first question that we had here today. A lot of people will say, well, I'm going to be passing my house on to whatever heir they have. Should I just put my heir's name on the deed for my house before I die, just to avoid this?
That's complicated. There are ways to do it. A lady was in my office this morning and wanting to do it. Under the current tax law, if I deed my property over to Trenton but reserve a life estate, then I get to file for that low tax rate. And I also get to benefit this beneficiary because at the time of my death, he gets to take it at the value at the time of my death. So I gave it to him, it was worth $100,000. When I died, it was worth $300,000. He takes it at $300,000, and if he sells it for $340,000, he only pays capital gains on $40,000. So there are ways to do that. Right. But you do lose control because if I give it to Trenton and reserve a life estate, I can't mortgage it, I can't sell it, I can't transfer it, I can't do anything with it unless Trenton agrees. So there are some complications, but there are ways to do it, and we probably prepare maybe 5 to 10 of those every month.
And if Trenton gets sued for something, then it comes back to you because you're in the same. As far as
it's a lien on the property,
right? Yeah, as far as that property.
Which means I think it would be subject to your life estate. I don't think they can partition you out or kick you out under a life estate. But
if you try to sell the property,
certainly.
What
So
you don't want to do is
go ahead,
deed it to them outright,
right?
Because there are negative tax consequences to that because it's a lifetime gift, and then if you're still going to reside in the property, then you're likely not going to be able to claim your primary residence tax rate. So.
All right, again, our phone lines are open if you have any questions about real estate law. And as along those same lines, let's go ahead and ask, okay, if you do die intestate without a will in the state of South Carolina, what happens to your property? I mean, your real property.
Well, it depends on who you leave behind. So there's an intestate kind of line of succession. So if you have a spouse, half of it will go to your spouse. If you have biological or adopted children, if you have no children and just a spouse, it all goes to your spouse. If you have no spouse but children, it all goes to your children. If you have no spouse or children, it goes to your parents. If not your parents, then your siblings. So I mean, it branches off depending on who you leave behind.
It's pretty streamlined as far as how to identify it.
Right.
The real kicker, though, is to make sure that if you do have a will, you have to file it within 10 years.
Yes.
Because if you don't file it within 10 years, if I left everything to Trenton and I didn't file it, and after 10 years, Trenton was one of my children, he would split it with, if I had a wife, she would get half. You know, the intestate rule applies as if
Right.
you didn't have a will if you don't file it within 10 years.
Yes.
Trenton, if I were you, I would check Ken's will just to see if they're in it, because it kind of seems that way.
I can redo it for you.
Also, a good note for wills is that you definitely want your personal representative to have the authority to deal with real property specifically laid out in the will, because if you don't have that in there and you pass away and your personal representative wants to sell real property, they'll need to get an order from the court as opposed to just being able to do it, which further complicates the process.
All right, our topic is real estate law, so let's talk more about real estate here. Now, as far as the general questions that you probably get right now is, I know you guys are the ones who do the closing, but the whole real estate business right now, I mean, what does it look like in the Myrtle Beach, Horry County area? I know that we have ups and downs over the past 5 to 8 years, and what does it look like today?
Our office we've been surprised. We've been busy. There was a little lull, I guess, at the end of the year, and we thought that it would be a normal lull in January, but it seemed like we began really early in January, and we've been pleased with the demand. I mean, a lot of people that still want to come, and most of them have the money to either buy in cash or get financing, and we're thankful. We're busy.
Yeah, I mean, same. We've always had a very strong market here in Myrtle Beach just because we're still affordable coastal living. We have, you know, attractive for investment property, retirement. Actually, our closings last year, we did more closings in 2025 than we did in 2021, which was the highest year, you know, during COVID for closings. So we're still a strong market.
Now, as far as interest rates are concerned, we've heard a lot about that over the last year plus. I mean, interest rates have gone down, you know, quarter point here and there, but we're talking about potentially, last I read, that it might go up just a little bit in this next change. How is that affecting as far as any of the business you guys are seeing?
Well, the market here in Myrtle Beach is certainly a function of the interest rates because we have so much investment property, and for many people, you know, their decision on whether to invest in real property is going to come down to, well, what kind of monthly payment am I looking for? Is it going to make sense with how much rental income I'm going to expect? And so if the rates get too high, then that doesn't make sense for a lot of people. So you'll have, you know, people holding on to their property, not selling, nobody buying, but things have been good lately, so hopefully they'll continue to stay that way.
Yeah, and one of the good things about having a market that's popular for retirement is we do get a lot of people from up north and out west who are selling their properties and coming here to purchase in cash, so not affected as much by the interest rate. So it definitely does have an impact on, like he said, investment property or first-time home buyers. But thankfully, you know, we have a good balance of lending versus cash transactions.
When you see a lot of changes in interest rates, you usually see a lot of refinancing. Has that been going on at all, or have the interest rates not been changing enough to see that?
Well, I have not seen a huge spike in refinances.
We've got a few. The general rule, I think, for most people is that if your rate is going to be decreased by more than 1% and you're going to stay there, then it makes sense to put the numbers on paper and see if it's worthwhile. Anything less than a 1% change in your fixed rate, if that's what you have, is usually not, it doesn't usually pan out. So.
Yep. In my B&I meeting yesterday, I think the lender in the group mentioned that anybody that originally bought at a 6.5% or higher should be kind of considering refinancing right now.
Right.
Anybody that's below that rate, it might not necessarily make sense.
All right, let's go back to the phones. Phone number is on your screen if you have any questions about real estate law here today on Legal Access. Stacy is in Myrtle's Inlet with us today. Hi, Stacy. Thanks for calling in. What's your question today?
Hi, Gabe. My question is, my mom passed away, and my brother and I inherited her condo. And in the process of, because it did, unfortunately, I wish I knew everything that you guys had been talking about prior, even though she had a will, that it still had to go to probate. She didn't realize that. We didn't realize that. So, but what my brother ended up buying, once it went through probate, my brother ended up buying me out. So he bought her condo. The HOA, my question is about the HOA. The HOA is saying that he has to pay, there were late fees or whatever that are owed on the, and that he has to pay that. And he's saying, well, if I'm a buyer, I know that I'm the son, but if I was a buyer coming in and I showing you the deed, I have the deed or whatever, wouldn't this now be in my name? That person has passed away, that gets erased. Besides the fact that, which is a whole other topic, she doesn't owe anything. There are no late fees. There's just, the HOA is confused. First they said that she overpaid and there was a $700 and something overpayment. Now they're saying that there's late fees. It's just ridiculous, and they can't get it together. They're short-staffed. That's a whole other issue. But the bottom line is, if somebody came in and bought that condo, they wouldn't have to pay any fees to the HOA, right? The HOA would now be in their name, and it would start new. Is that correct, or are we wrong?
Well, obviously, the controlling documents are your master deed and your HOA documents. That's sort of the roadmap. That's what's going to dictate who's responsible for what. And I think, generally speaking, the only way to avoid HOA fees in a scenario like that is if it's wiped out through a court order. An HOA is bound by the responsibility to raise money to keep the maintenance, upkeep, reserve funds, et cetera, in place, and that doesn't go away just because someone dies. So it's critical that, one, the documents that created it are paramount to review, and secondarily, many times you're obligated, and I think probably foreclosure or some other court order avoiding that would be the only ways that I can recall to avoid those fees. But many times the HOAs don't get it straight. You've got, sometimes they're managed by people that own units in there, sometimes they're managed by super mega companies, and we face this all the time because we have to rely on the written statement from the HOA, and we have disclosures that say if they're wrong, then it's up to the parties to fix that, because we can only rely on what they give us. And that's sort of the dilemma that sounds like you're in.
Right.
Now, Stacy, when your brother bought the property from the estate, did you go through an attorney who handled the closing and have a contract? Oh, okay.
Yeah, Stacy's not there at the moment.
Gotcha.
I'm assuming that what happened is, because the obligation to pay HOA dues is not just a personal one, it runs with the land is the term we use. And I'm assuming that in that situation, because it was a buyout through the estate process or immediately afterwards, you may have owned it 50-50 and he may have just been buying out your half, that you probably didn't obtain what's called a certificate of assessment from the property management company or from the HOA. In a normal arm's length transaction where a property is being transferred, you get that document and you can rely on it, because otherwise the buyer comes in and they are responsible for those dues.
Stacy, hopefully that helps you out, and I'm sorry for your loss. If you have any other questions, we do have a couple of people on hold right now. Stay on hold, but we do have to run to a break real quick. We'll be back in about 90 seconds, and we'll answer your questions live on the air here. It's Legal Access, brought to you by the McGuire Law Firm. It's Legal Access, brought to you by the McGuire Law Firm. Real estate law is our topic here today, and we've got a lot of great phone calls. We've got a couple more to get to right now before the end of our show in just a few minutes. Let's go to Tony first of all. Tony, thanks for being patient through the break. What's your question for our panel today?
Yes, sir. How are you all doing? And thank you for accepting my question. So my question is, with the real estate part, if all of your stuff is paid for, your land and your home, do you quick claim deed it so that your beneficiary can be on it? What do you do in that particular case so that it will not have to go through probate, or is it such a thing?
Well, You've got a couple options. We'll sometimes use a life estate deed in that instance, rather than adding someone to the title during life. You could do that, and you could have the right of survivorship between yourselves, but I think that would be maybe negative tax consequences to that, because that would be considered a lifetime gift of the portion of that interest. So a life estate deed or some other method through like a formation of a trust would probably get the trick done there.
Yeah, I would say if you have all your property paid for and you're worried about the future, you need to see a lawyer and just get an estate plan in place so that can address all that.
Right. All right, Tony, thanks for calling in. Hopefully that answers your question. Let's go to Bob in Myrtle Beach. Bob, thanks for hanging on through the break there. What's your question for our panel today?
It's not directly related to real estate law, but indirectly. And the question is, who would be a candidate for a trust over a will, and what kind of costs are associated with? I know you don't have to be specific about either one, but I'd like to know about how much it costs to get a trust prepared if I would be a candidate for that.
So wills have a tendency to be cheaper, obviously, because they're less complex documents. So typically an estate plan with a simple will run you anywhere from $700 to maybe $1,000 plus or minus. Trusts have a tendency to start in the $2,000 to $3,000 range and up. A good candidate for a trust is someone that wants some control over their assets after they pass away, someone who has minors, special needs, heirs, someone who has significant assets and they're trying to avoid some tax implications or set up generational wealth.
Right.
So if you just have some things and you want them to go to specific people, I would recommend a will. If you want more control or have more significant assets, I would explore a trust.
One other thing about trust too, if you have property in more than one state, that's certainly something you would want to consider, so you don't have to probate in 2 states.
Yep.
And I see blended marriages, whether you remarried where you have kids that aren't biological kids, that's usually something that could be subject to a trust as well.
We got an extra minute. So we have an extra minute here. Let's talk about if somebody wants to move into an area and they buy property from out of state to live here, and they want to open it as a Airbnb or a Verbo, but they find out once they get down here that the HOA doesn't allow it or it's not zoned in that area. Do they have any kind of recourse at that time?
Unfortunately, the standard South Carolina contract is kind of buyers beware where that's concerned. There's a section that says that the buyer has taken the opportunity to investigate all matters with regards to the HOA. So if you are buying a property specifically to turn it into a VRBO or an Airbnb, you need to know that you can do that before you sign that contract.
It's too late after you buy it, that's for sure.
Yep.
Yeah, and it's important to check both your HOA related documents and also the zoning as well, because either one of those could prohibit it. So.
Yeah.
Speaking of HOAs, I know that they passed some laws in South Carolina as far as what needs to be revealed to a buyer as far as HOAs are concerned. Is there anything new about that? Or I know a lot of people are interested in their HOAs.
They say that Horry County might be the most heavily litigated HOA county, not only in the state but maybe in the country. So I don't know that there's any move to streamline it. It's just can be complicated, and if you have an HOA question, seek a qualified attorney that deals with HOAs.
Tell you what, we're going to have to run to the end of our show here. We appreciate all the phone calls we've had today. We've been talking about real estate law and estates. We've had a lot of questions about that as well. If you have any questions that we didn't get a chance to answer, you can email and we'll answer you off the air. legalaccess@WMBFnews.com. Make sure and email us. Next week when we get together, we're going to be talking about personal injury. I want to thank our panel here today, Ken Corbett, Trenton Redmond, and also Kimberly Thompson. I'm Dave Priest. See you next Thursday here on WMBF News.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by